now, the sole thing that Ms. Merchant is trying to do is hand him an object to refresh his recollection again. So we'll see where we get with that.
And I don't have any written down with it. He doesn't have
May I one
Mr. Seda.
The court is a trier of fact. You're going to be able to determine whether something that has come in that you choose is hearsay, whether it's admissible, whether it's relevant, whether it's impeachment. You're in a position that if it all comes in, but you reserve the right, or all parties reserve the right to object, we can deal with it. This is not a jury. We don't have to worry about the jury hearing something that it will no longer consider. All we're doing now, with all due respect, and I understand there's a process, the state doesn't want something to be heard.
I object to that.
They've repeatedly attempted to stop questioning. Your Honor can hear it all and then decide what is and is not relevant or admissible. We don't have to go through every single one of these. The only time you have to go through this is if it is in fact a communication and it's a privileged communication, and an argument has to be made at that point as to whether or not it should be elicited or it is subject to being stated in open court. Otherwise, all of this could come to the court, and the court can then decide how it wants to treat it. That's
all right. I appreciate that, Mr. Seda, and I think it's certainly accurate that we could have an approach where if it's a close toss-up on an evidentiary question, we can have it all come in and sort it out later on the record. I don't think we've quite reached the point where I need to do that. I think we still have time to get into these, and it'd be my preference to keep the record as clean as possible and without questionable evidentiary issues. But we may get to that point. So